The Constitution is the supreme or highest law in Zambia. This means that all other laws should align with the Constitution. The Constitution performs several important functions. These include the following. It determines how power is exercised in the country. It defines how leaders are elected or appointed. It protects the freedoms and rights of citizens while providing ways for citizens to participate in governance. It outlines the responsibilities of citizens, and it defines the structure and functions of government. Zambia's constitution has changed several times since independence. Major reform processes include the Chona Constitution Review Commission of 1973, which culminated in the 1973 Constitution, Muvunga Constitution Review Commission of 1991, which resulted in the 1991 Constitution, Manakatwe Constitution Review Commission of 1996, which led to the 1996 Constitution Amendment, Mungomba Constitution Review Commission of 2005, the Zalomis-led Electoral Reform Technical Committee of 2005, and the Anel Silungwe-led Technical Committee on Drafting of the Constitution of 2012, among others. Each constitutional reform reflected changing national priorities and governance needs. Over the years, stakeholders across Zambia have continued to raise both long-standing concerns and new issues relating to the Constitution. In March 2025, the Minister of Justice, Honorable Princess Kasune, MP, presented a ministerial statement in Parliament where she outlined a roadmap for the constitutional review process and detailed 13 thematic areas for proposed reform, which included the limitation of new constituencies and wards by the Electoral Commission of Zambia, adoption of an electoral system that enhances the representation of women, youth, and persons with disabilities in the National Assembly, and the increase in the number of nominated members of Parliament, among others. These thematic areas inform the Constitution of Zambia Amendment Bill 2025, which generated extensive national debate and opposition from various stakeholders, both in relation to its substantive provisions and the process adopted in its development. As a result, the bill was deferred to allow for broader stakeholder consultations. In October 2025, the President of the Republic of Zambia, Mr. Hakainde Hichilema, appointed a 25-member technical committee on consulting and drafting amendments to the Constitution. The committee was tasked with conducting a consultative and inclusive review of provisions of the Constitution identified as requiring amendment. Consultations were conducted across all 10 provinces of Zambia through both online consultations and in-person submissions. The result of this was the Constitution Amendment Act No. 13 of 2025. Now that we understand the background of the reform process, let us turn to some of the most important changes introduced by the amendment. In Zambia, citizens vote in 3 main types of elections: presidential elections, parliamentary elections, and local government elections. For presidential elections, a candidate must receive more than half of the votes cast in order to be elected. For parliamentary and local government elections, members of parliament and councillors have traditionally been elected using the first-past-the-post system, where the candidate with the highest number of votes in a constituency or ward wins the seat. While this system is simple and widely understood, women, youths, and persons with disabilities have historically been underrepresented in both parliament and local government. The 2025 amendment does not change how the president is elected, and voters will still elect members of parliament and councillors in their constituencies and wards using the first-past-the-post system. However, the amendment introduces an additional layer of representation through a system known as mixed member proportional representation. In simple terms, the existing constituency and ward seats remain the same, but additional seats will now be added to improve representation of groups that have historically been underrepresented. These additional seats are reserved for women, youths, and persons with disabilities. Unlike constituency or ward seats, these seats will not be elected directly by voters. Instead, after the election, the Electoral Commission will allocate them to political parties based on the number of votes received by each party's presidential candidate. This change aims to ensure that Parliament and local government better reflect the diversity of the Zambian society. The effectiveness of this reform would largely depend on amendment to the Electoral Process Act No. 35 of 2016, and on how political parties select candidates for their party lists, since the Constitution does not provide a specific procedure on this process. This brings us to the next amendment. The changes introduced under Article 47 also affect the structure and composition of the National Assembly. Before this amendment, the National Assembly consisted of 156 elected members of Parliament, together with up to 8 nominated members, the Vice President, the Speaker, and 2 Deputy Speakers. The 2025 amendment increases the number of constituency-based members of Parliament from 156 to 226. This means that additional constituencies will be created through a process known as delimitation, which is carried out by the Electoral Commission of Zambia. Delimitation involves reviewing and adjusting constituency boundaries in order to determine where the new constituencies will be located. In addition to the 226 constituency-based members, the National Assembly will also include the 40 proportional representation seats introduced under Article 47. These seats are reserved for 20 women, 15 youths, and 5 persons with disabilities, with the aim of improving representation for groups that have historically been underrepresented in Parliament. The amendment also increases the number of nominated members of Parliament from 8 to 11. However, the Constitution provides that the number of nominated members must not exceed 5% of the members holding constituency-based seats. This ensures that nominations remain limited and do not overshadow elected representation. Taken together, these changes expand the National Assembly and aim to ensure that Parliament better reflects the diversity of Zambia's population while strengthening representation across the country. Free and fair elections are not only about voting. Free and fair democratic elections also require clear rules governing nominations, election disputes, and the resolution of disputes. One amendment to Article 52 concerns the time frame for resolving challenges to a candidate's nomination. Previously, the Constitution required a court to hear a matter challenging the nomination of a candidate within 21 days of the challenge being filed. However, the Constitution did not expressly require the court to determine the matter within the same period. This issue was addressed by the Constitutional Court in the case of Bernard Kanengo versus the Attorney General and the Electoral Commission of Zambia, where the court clarified that a matter must be heard within 21 days and that this period cannot be suspended or extended by any court or authority. The amendment now clarifies that the court must both hear and determine the matter within 21 days. This helps ensure that disputes about nominations are resolved quickly and that elections proceed with greater certainty. Similar clarifications have also been made elsewhere in the Constitution. Article 73, which deals with election petitions from members of Parliament, now requires that such petitions be heard and determined within 90 days. Article 103, which relates to presidential election petitions, requires that these matters be heard and determined within 14 days of filing the challenge. Together, these changes aim to ensure that electoral disputes are resolved within clear and predictable timelines. The amendment also changes what happens when a candidate dies, resigns, or becomes disqualified after nominations have closed. Previously, the Constitution required that in any of these situations, the election would be cancelled and fresh nominations would be invited from all candidates. Under the amendment, if a candidate resigns or is disqualified by a court, the election will proceed as scheduled, and the candidate who resigned or was disqualified will not be eligible to contest that election. However, if a candidate dies before the election will be cancelled and fresh nominations will be invited from the political party whose candidate died, and the election will proceed. These changes aim to reduce unnecessary disruptions to the electoral process while ensuring that disputes are resolved within clear constitutional timelines. Another important reform concerns the vacancy of ministerial offices before a general election. Previously, the Constitution did not clearly state when cabinet ministers and provincial ministers were required to vacate office before elections. This issue was addressed by the Constitutional Court in the case of Stephen Katuka and the Law Association of Zambia versus the Attorney General Ngosa Simbiakula and 62 others, where the court clarified that ministers were required to vacate office upon dissolution of Parliament. The 2025 amendment now expressly provides for this rule in the Constitution, effectively giving constitutional effect to the interpretation made by the Constitutional Court in that case. Cabinet ministers and provincial ministers must now vacate office when Parliament is dissolved 90 days before a general election. This reform promotes fair competition among political candidates and strengthens public confidence in the neutrality of government institutions during elections. The amendment also introduces changes relating to the composition and term of local councils. Previously, a council consisted of elected councillors, a mayor or council chairperson, and not more than 3 chiefs representing chiefs within the district. The amendment now also provides for the Member of Parliament representing a constituency within that district to be part of the council. Another change concerns the term of office for councillors. Previously, councillors were elected for a 5-year term from the date of election. However, councils were dissolved 3 months before a general election at the same time that Parliament was dissolved. In practice, this meant that councillors never completed the full-year term. The amendment now clarifies that despite the early dissolution, councillors will be deemed to have completed their 5-year term for all legal purposes. This change provides greater clarity and certainty regarding the tenure of councillors and local councils. Another amendment relates to the qualifications and tenure of mayors and council chairpersons. Previously, the Constitution did not clearly set out the qualifications for a person seeking election as a mayor or council chairperson. The amendment now clarifies that a candidate must be a citizen, be at least 21 years old, be a registered voter, possess a grade 12 certificate or its equivalent, and declare their assets and liabilities. Another important change concerned term limits. Previously, mayors and council chairpersons were limited to 5-year terms. Under the new framework, the Constitution removes these term limits. This means that voters may return mayors or council chairpersons in office for as long as they continue to be elected. Previously, the Constitution provided that a person qualifies to be appointed as secretary to the cabinet if that person has or had at least 10 years' experience as a permanent secretary or equivalent rank. The amendment now adjusts the qualification requirements for the office of secretary to the cabinet by reducing the prerequisite years of experience to 5 years as a permanent secretary or its equivalent rank. This change aims to broaden the pool of suitably qualified candidates eligible for the position and ensure accessibility to a diverse range of potential applicants. One clarification concerns the definition of a child. Previously, the Constitution defined a child as a person who had attained or was below the age of 18 years. The amendment now clarifies that a child is below the age of 18 years. This change aligns Zambia's constitution with widely recognized international standards, including the Convention on the Rights of the Child. The amendment also introduces new definitions such as constituency-based seat and ward-based seat. These definitions were necessary to support the operation of the revised electoral framework. Taken together, the 2025 constitutional amendments represent an important step in Zambia's ongoing constitutional development. They reshape aspects of the electoral system, expand representation in parliament, strengthen electoral procedures, and introduce mechanisms designed to promote fairness, inclusivity, and accountability in Zambia's democratic process. However, constitutional reform is only the first step. The true test lies in implementation and public understanding. A constitution is not only a legal document, it is a living framework that shapes how citizens choose their leaders and participate in governance. Understanding the Constitution is therefore one of the most important steps in strengthening democracy in Zambia.